right, let's just picture something for a second. You're at home, it's late, and then a loud knock on the door. It's the police. And they say a complaint has been filed against you by your spouse. Something like dowry harassment.
A really serious charge.
Exactly. And they're there to take you to the station. Right now,
Yeah.
you try to explain, but they just say, sorry, it's non-bailable. You have to come with us.
It is a genuinely terrifying scenario.
Yeah.
And for a long time, that fear of, automatic arrest, it was very, very real.
It was. But today, we're going to dig into a landmark Supreme Court judgment that basically drew a line in the sand on this. We're talking about Arnesh Kumar v. State of Bihar.
And it's a case that asks a really critical question. Just because the police have the power to arrest you, does that mean they have a duty to do it?
Ooh, I like that phrasing. Power versus duty. So let's get into the story. Who was Arnesh Kumar?
So Arnesh Kumar got married to Sweta Kiran back in 2007. And, well, the marriage didn't last long. Sweta alleged that Arnesh and his family started making dowry demands.
And these weren't like small demands, right? I saw the record.
Yeah, not at all. She claimed they wanted 8 lakh rupees, a car, an AC, a TV, a whole list of things. She said when she couldn't provide them, she was thrown out of the house.
So she files an FIR under Section 498A, the Dowry Harassment Law.
Right. And 498A is a cognizable offense. That basically means police can arrest without a warrant. So Arnesh, obviously terrified of getting thrown in jail, he applied for anticipatory bail.
And let me guess. The lower court shut him down.
Completely. Both the Sessions Court and the High Court rejected his bail pretty much mechanically just because the offense was a serious one.
So there was no real consideration of the fact.
It seems not, and you have to understand the context here. By 2012, we're talking about nearly 200,000 arrests under just Section 498A in a single year.
Wow.
Yeah. The Supreme Court itself noted that this law, which was created to be a shield for women, was being used more and more as a weapon, a way to harass husbands and their entire families.
So Arnesh takes his case all the way to the Supreme Court. And this is where things get really interesting, because the court looked beyond just his bail.
Exactly. They hit the brakes and decided to look at the entire system of arrest. They focused on Section 41 of the Code of Criminal Procedure, or the CrPC.
Okay, so what did they find there?
They made a crucial clarification. For any offense where the punishment is 7 years or less in prison, which includes 498A, the law says a police officer may arrest.
May, not must.
That is the entire point. It is not automatic. The court said arrest should be the exception, not the rule. And to enforce that, they created something called the checklist.
A checklist? What's on it?
An officer can't just arrest you on a whim. They have to write down specific reasons, and those reasons have to be justified.
Justified how?
Well, they have to show the arrest is necessary. For example, to stop the person from committing more crimes, or to make sure they don't tamper with evidence or, threaten witnesses.
So if they can't tick one of those boxes, they can't just make an arrest.
They can't. And it doesn't stop with the police. The court also came down hard on magistrates.
How so?
They said too many were acting like clerical staff, just rubber-stamping detention orders. Now, a magistrate must check that the police have filled out that checklist and provided valid reasons. If they haven't, the magistrate is supposed to refuse detention.
That's a huge check on power. And wasn't there another alternative to arrest they highlighted? Section 41A.
Yes, the notice of appearance. It's a game changer. Instead of just arresting someone, the police can issue a notice that requires you to show up for questioning.
And as long as you cooperate.
So as long as you cooperate, you generally shouldn't be arrested. It's a system built on respecting a citizen's liberty first.
So let's tie this all together. What do the Arnesh Kumar guidelines mean for the average person listening?
It's incredibly empowering, really. The main takeaway is this. If you're ever facing a charge with a punishment of under 7 years, you cannot be arrested automatically. That's the bottom line.
And if you get one of those Section 41A notices,
cooperate. Go to the station. Answer the questions. Complying is your best protection against arrest.
And for any lawyers or law students listening,
your duty is to demand that checklist in court. Make the police justify why locking someone up is absolutely necessary. It's about holding the system accountable.
It's a massive shift then, a real victory for civil rights, making sure liberty comes first.
It truly is. But, it does leave us with a final kind of provocative thought to mull over.
Go on.
The Supreme Court has laid down these clear protective guidelines on paper, but the real question is, has the culture on the ground actually changed? If you walk into your local police station today, are these rules being followed, or is the threat of arrest still the first tool they reach for?
That is the real question, isn't it? Thank you for listening to this deep dive. Stay safe out there.